Divorce decrees aren't always set in stone. The 1985 case of Naylor versus Naylor demonstrates what changes in circumstances Utah courts might look for when granting or denying modifications. Robert Naylor and Julia Naylor divorced in 1978. The Naylors were married for 11.5 years. At the time of the divorce, Robert had just become a surgeon after finishing medical school, and Julia had just become a hairdresser after finishing training. The couple had a child. As of the initial divorce decree, Robert was making $2,600 per month, and Julia was making $702 per month. Julia was awarded alimony of $500 a month for 5 years, and child support for $250 a month until the child turned 21 or left home, or a modification was ordered by the court. After 3 years, Julia filed an action to modify the decree. When the action was tried 2 years later, Robert was a shareholder in his medical practice. His base salary was $5,000 a month, and he had earned annual bonuses. His bonus in 1979 was $15,000 and had increased to $23,500 by 1981. He also received contributions to his pension and profit-sharing accounts at around 25% of his gross income. Julia had expected to establish herself as a hairdresser after becoming one around the time of the original divorce decree, but this hadn't occurred by the time the case went to court. Her income only grew by $18 to $720 a month. Their child had become a teenager and had more expenses. Julia and the child's living expenses increased by $730, from $1,450 to $2,180. Julia had to borrow over $13,000 since the divorce to support herself and her child, even after her income, alimony, and child support. The trial court found Robert had the ability to pay an increased and extended award. It modified the decree to increase alimony payments by $100 per month and extend them by 4 years, and increase child support from $250 to $400 per month. Robert appealed the order granting the modification,